Aloha and welcome to Ehana Kako. We're a weekly program on the Think Tech Hawaii Broadcast Network. I'm Keli'i Akina, president of the Grassroot Institute. Have you ever wondered what's going on at the courts, whether it's the Supreme Court here in the state of Hawaii or nationally? Sometimes it's not too clear to those of us who are laypersons, not attorneys necessarily, observing what's taking place. Sometimes we throw up our hands and say, what's the court doing? Has the court gone crazy? But you know, with careful analysis of what's taking place, I think we can have a more studied response. And I think there are very few people who are as adept at understanding what's going on in the world of litigation here in Hawaii and nationally as my good friend Robert Thomas. Robert Thomas represents the Pacific Legal Foundation, although he's here today not on their behalf. And he's also an attorney with the local firm Damon Key. But more than that, Thomas understands what Hawaii is all about. And that's an important background to have when looking at what's going on in the courts. So stay tuned all throughout the show. We're going to cover some interesting territory. We're going to talk about the 30-meter telescope. We're going to talk about a pig hunter who has rights as a Hawaiian to go onto private property and hunt pigs. We'll also talk, of course, about something we've covered quite a bit over here, what's going on with the state's effort to create a race-based election and have a race-based constitutional convention to start a foreign country here in Hawaii. Robert Thomas has some interesting perspectives on all of this. Robert, aloha, welcome to the program.
Aloha, Keli'i. Thank you for having me on today.
Well, I'm delighted. You've been practicing law here in Hawaii all of your career, practically.
Yes, with a couple of exceptions since, 1987.
And you're in private practice, but you also served in a public policy law firm.
That's correct. What you
Public interest law
yes,
firm.
what you mentioned earlier, the Pacific Legal Foundation, which is based in Sacramento, but has regional offices around the country, including Hawaii. On that, of cases of public interest, we will represent people for free.
Oh, well, that sounds good.
On certain issues.
Certain issues. They have to be issues that rise to the level of public interest, as you say.
That's correct.
And what does that mean?
Well, it's going to have an effect more than just on the party themselves, on the client themselves. It will have an effect on either changing the law, making the law better, making the law more certain in certain topics.
So it's really something that has to be pursuant to the public good.
Exactly.
Well, very good. Well, you know, you've been very involved in watching some cases here recently, and I know you've commentated in your own blog, inverse condemnation, right?
Yeah, it's a mouthful, but it's inversecondemnation.com, yes.
And one of the pieces that I found most interesting was one when you started to comment on the 30-meter telescope. Now, we've got viewers from across the world, and they may not be aware of what's going on here. And just to kind of summarize it, a 9-year process took place in which several countries, universities, pooled their resources, raised about $1.4 billion in capital, virtually got every permit completed, and we're about to begin construction to build a tremendous piece of technology, the 30-meter telescope on Mauna Kea on the Big Island, and then boom, all of a sudden it all just kind of fell apart. What happened?
Well, yes, it's we're lucky, I guess, in the sense that the mountaintop on the Big Island, 14,000 plus feet, I think it is one of the few places in the world without light pollution, away from cities, but yet accessible. And so there's been a series of telescopes, research telescopes, built up there over the years, and I think right now there are 12 of them. And the proposal was to make one more, the 13th, called the 30-meter telescope, because I think that's the focal length of the telescope. And with that, I say it's like a Star Trek. They can look deep, deep, deep into the heavens and come up with all sorts of things that astronomers and physicists love to do.
So it would have been something very valuable in terms of science as well as the economy and certainly the prestige of Hawaii being able to have such a telescope in place.
Billions of dollars to the local economy, potentially. World prestige, because there's only a few sites in the entire world that are similarly situated. And this one has the advantage of being in the United States, which gives it a sense that there's certain protections that come along with being in the United States that you may have to worry about in other locations.
Now, when construction was supposed to begin, this made global news all of a sudden. And walk us through what happened. We were starting to see images of individuals who said they were Native Hawaiians opposing this, ostensibly because the telescope was going to be built on sacred ground.
That's correct, and as I understand it, there are people, some, and I can't speak to the genuineness of the belief or not, but generally the courts don't look into the genuineness of someone's belief when it comes to asserting something as religious or sacred. And that claim was made. Now, the claim may have been made before with the other 12 telescopes, but for whatever reason, those did not seem to generate the amount of controversy that for some reason the 13th telescope did. And remember, the top of these mountains, and I think most mountains in Hawaii, are state-owned land. And so before the University of Hawaii, which is a state institution, could build anything there, it needed what's called a conservation use district permit.
Okay, conservation use district permit.
Right, because this is a conservation, mountaintops are conservation land, state-owned, and as the name implies, the general point of this is to conserve the land, but when you talk about a conservation district use permit, there's also some permitted uses, among them things like science and whatnot, like the telescopes,
So
the 12 telescopes that exist there already.
While there are many political and social issues involved in the TMT progress or lack of progress, the permit you talk about becomes the centerpiece of the litigation that
Right.
goes forward. Tell us a bit about
Like
that.
everything, it seems, in Hawaii, what starts off maybe as a cultural or a political or a policy question soon become legal questions. And on this one, a challenge was made to the issuance by the Board of Land and Natural Resources, which is a state agency that controls or at least issues permits for state-owned land like this to use it.
What was the claim by those who were challenging the legitimacy of the permit?
Well, they made two claims. They said, first of all, the process was foul, that they called foul because they said on these type of things, you're supposed to have a hearing first before you determine whether a permit issues. But on this one, the Board of Land and Natural Resources, as the Supreme Court later said, got the cart before the horse. They issued the permit first, followed then by process and
So that's a
determination.
standard operating procedure they claimed was not followed.
That's true. I mean, everything from the U.S. Constitution on down requires these type of things before you make decisions. You're supposed to have the hearing first, not afterwards.
And that's going to factors significantly in the ultimate decision that the court would make.
That's correct. The one that was made roughly, I guess now about a month ago, the Hawaii Supreme Court decided that. But the second claim that was raised was one as to the substance, that if you add up all of the factors that the board was supposed to look at to determine whether this was an appropriate use of conservation district, that the board made the wrong decision. I mean, not just on process, but actually they should not have issued the permit regardless of whether they followed the right process or not.
Now, while I followed these two claims, somewhere in the maybe 10th page of the newspaper or at the bottom of the page, it seemed that during the period of time in which protesters were making their case known to the public, the issue was about religion, the issue was about politics, the issue was about the way our governor governed and so forth. So really, in the end, it's these legal issues that surface as determining what's going to take place with the telescope.
Right. Cultural issues, political issues, religious issues. You'll win or lose in the legislature or lobbying your government or petitioning your government, going to the governor, going to the board, going to the legislature. But sometimes, a lot of times, that doesn't work. They listen to somebody else. And at the same time, you will always see this, almost always see this parallel track where the challengers who don't like something will say, well, you not only shouldn't you do it as a policy matter, but you can't do it as a legal matter. And we've seen that time and time again. Here, I think the public's very familiar with that, things like Super Ferry.
That's right.
Every major development project that goes on any island will get challenged in court. Regardless of whether it's a good idea or not, they will look at whether the permits or the approvals were
That's right.
legitimately issued.
So as you mentioned policy, it seemed in the eyes of the public what was being argued was whether to have a telescope or not. But as you point out, it's really all about the permit and whether that is legitimate. Now, let's go to what the court ultimately decided. What did the court decide with respect to these two claims?
All 5 justices came
And
to
you're talking about the Supreme Court of Hawaii.
Supreme Court of Hawaii, like behind us. All 5 justices, they had different reasons, but all 5 justices agreed that the process that the BLNR followed to issue the conservation district permit was faulty. That essentially what happened was the board decided first and then had the fair hearing, which is sort of completely backwards from what we think of in our system.
Well, I've got a question. It's not a question about law,
Right.
but how on earth did that happen? Was it sloppiness? Was it lack of knowledge of procedure? Was there a behind-the-scenes political move?
No, I don't think so. I mean, I'm not really privy to the exact reasons, but it's not that surprising to me for a couple of reasons. First of all, this is administrative law. BLNR is a state agency, meaning it's within the governor branch. It's not a court. It's not an arm of the legislature. It's either a third branch of government, part of the executive, or maybe even kind of a fourth.
Now,
a
I
little bit
hear
independent.
your bit of tentativeness
Yes.
over here, because, when I went to high school and I learned about the three branches of
Three,
government,
not four, right?
the judiciary, the legislative, and the executive.
Yes.
I really wasn't aware of this shadow fourth branch of government. So what you're pointing out is that there are laws that are passed by the legislature, signed into law by the governor, and then adjudicated by the courts.
Yes.
We're familiar with that kind of law,
Yes.
both at the local level and the federal level. But you're saying administrations themselves, the executive branch, is able to pronounce rules
Yes.
through its administrative agencies. And that becomes another kind of law.
Yes.
And there are even courts that actually adjudicate those laws and so forth. I mean, just ballpark. Is there a little bit of that kind of law out there, or a medium amount, or a very
a
big
huge amount, and some estimates have put it as the largest branch of government.
There you go.
And they're not elected, they're not appointed, or they're appointed. A lot of them are we talk about the boards, this, and the Civil Service Commissions, and the Public Utility Commission. Those are examples, and I couldn't have said it and summarized it any better than you just did.
Now, presumably, those administrators in the administrative branch that are making these rules and regulations that are de facto law are basing that upon the Constitution and the laws that are made by the legislature in the first place.
That's correct.
They should be amplifying that or clarifying it.
Clarifying it.
Clarifying
Because, the
it.
legislature may not have the time when it passes these broad statutes to fill out the details of how it's implemented. And that's what these boards and agencies are supposed to do, as well as most federal and state agencies have another function that's almost like a court.
But I can imagine that it could get pretty far away from original intent of the law as the legislature may pass that.
Yes. In short, yes.
And that's why we need the courts to reel them back in.
Yes.
So let's go back then to this situation where a permit did not, the right process was not followed in the granting of the permit. So ultimately, what did the courts do?
Well, the courts invalidated the permit. They said you have to have, without even getting into the substance of whether the permit was correctly issued as a matter of whether they followed the right substantive guidelines, they said procedurally it was wrong because you cannot issue a permit and then say to people who object to that, well, I'm then going to give you essentially a fair trial to challenge the permit after it's been issued.
So the force of that decision was to just put everything on hold until the permit can be reviewed again?
Yes.
By whom?
By the BLNR.
The Board of Land and
Board of
Natural
Land and
Resources.
Natural Resources. The court, what the technical term is, vacated the permit that was issued and remanded the case back ultimately to the Board of Land and Natural Resources and say, try again.
When we come back from a break, I'm going to ask you, who is the Board of Land and Natural Resources? Are they the same people who granted the permit in the first place, or has there been some evolution? I hope you find this conversation with Robert Thomas as fascinating as I do. It's not only a look at the issues, it's a look at what takes place behind the scenes that we often don't see in terms of both the political and the legal world. I'm Keli'i Aquino with the Grassroots Institute on Ehana Kako on the Think Tech Hawaii Broadcast Network. My guest, Robert Thomas, and I will be right back after this short break.
Aloha. Welcome to Think Tech Hawaii. My name is Josh Green. I'm a senator from the Big Island and a physician. I host a show weekly called Healthcare in Hawaii, where we talk about the most important issues in healthcare for our state, whether it's the dengue fever outbreak, the state of our public hospitals, how to find physicians and nurses for our patients, or really just the best things to do for our family's health. That's what you'll find on this show. I'll bring experts to your attention, and we'll have a free-flowing dialogue. Thanks for joining us.
Aloha, my name is Kaui Lucas. I am the host of Hawaii is My Mainland, here every Friday on Think Tech Hawaii at 3 p.m. I invite people who are doing interesting and inspiring things in our community to help us keep it local and keep it real. Tune in any Friday, 3 p.m., and also available on our YouTube channel and my blog, Keli'iLucas.com. Hawaii is my mainland. Aloha.
Welcome back to Ehana Kako. We're here every week on the Think Tech Hawaii Broadcast Network, which reminds me to say mahalo to my friends at Think Tech. What a great organization. Jay Fidel, as president and founder, has set up a wonderful group of people who produce about 35 hours of live content, great content here produced in Honolulu, Hawaii, and broadcast across the world, thanks to the wonderful team. My guest today, Robert Thomas, is giving us some tremendous insights into how things really work. And in fact, that's a good reason to consider going into a career in law, perhaps, if you're looking for a future where maybe you're not too concerned about making a living right now, but at least understanding how things are going. Robert, I just find this absolutely fascinating to understand how much administrative law that nobody sees being made actually rules the day. And so basically, this 30-meter telescope process went afoul by violating some administrative rules, in particular, the order in which you issue a permit or allow any contested feedback to it.
Right. Ultimately, I think it's beyond sort of the scope of our discussion today to talk about the exact legal reasons, but ultimately the court said it was a matter of constitutional law that the BLNR, the Board of Land and Natural Resources, violated. We're all entitled to procedural due process, both under the state constitution and the U.S. Constitution.
So in their interpretation, they anchored it
Yes.
in an authoritative source, the Constitution itself.
Can't get much more authoritative than that, I guess.
But the actual process by which these rules were developed and in which they became practiced was actually administrative.
Yes, and I think in light of the court's ruling and the board's practices up to now that got them in trouble, the board's going to have to go back and look at their practices and figure out a better way to do this. Because you asked me earlier in the first session, what was the board thinking? I mean, because if you read the Supreme Court's 100 pages of opinion, you'll think, my gosh, why would they think that this process that they used, permit first, process second, was going to work? Well, they're not stupid, they're not crazy, they do the best they can, but I think you alluded to it. Administrative law can be very confusing. They wear several hats. Boards such as this wear hats where they make rules, which are prospective rules, so they're like a legislature. Right. They also sit like judges and decide whether certain permits should issue, which is what they were doing here. And it's hard sometimes to tell when one hat goes on and the other goes off.
And with due sympathy to them. I've been at some of these meetings. They're frequently open to the public.
Yes, they do their best.
And sometimes 3/4 of the people are wearing red-colored T-shirts, presenting colorful language all throughout this. There's a great deal of pressure on these people, and frequently the board members aren't professional politicians.
A lot of them are volunteers.
They're not lawyers.
They are not lawyers.
And so
they are people doing a civic duty. They're doing their best for the most part.
And while I sympathize with this, it creates a problem for the public, wouldn't you think? That
yes.
we don't really know who to hold accountable. In the last session, we closed with this. You said that the courts had vacated the permit, in other words, invalidated it, and sent the TMT process right back to getting a permit again, to the board. But this board now, are they the same people who issued the permit in the first place?
They're the same official board.
The same body.
But it's a whole different set of people, because in the time
individuals.
since they first issued the permit a few years ago, new administration comes in, new people appointed, people term off, term on. It's literally a whole new board.
So now, if we wanted to say, well, off with the head of the guy who broke the process of the rules, who let them have the permit without going through due process.
He or he's gone.
We have no head.
He or she's gone.
And we have no head. We have a committee.
Right. And they were, again, I disagree with many of the comments that you see maybe on the internet or someplace
Sure.
else that said these guys were in the pocket of one side or the other, that they have this bias. They really are trying.
It's not that conspiratorial.
The problem is the way that the practicalities some line up with what the rules are. A lot of times they are making it up as they go along, and I don't use that in a bad way, but because a certain situation has never arisen before, they do the best they can, and a lot of times, many times, it doesn't pass muster.
Well, before we leave this topic, just for the benefit of some of our out-of-state people, this has been in the news, and this isn't a legal issue, but where does this put the TMT Corporation, the consortium? If they want to proceed, what do they need to do?
Square one. I mean, not quite square one, maybe square two, because their application, unless something has changed in the application, their application, I assume, is not affected by the court's decision, but it's right back to the board again. So, years and years of process. I think the actual hearing process that took place in the board was over a year in length plus. So go back, start again. We've seen in the papers some questions about whether they can sustain it. In Super Ferry, for instance, they've decided it's not worth it, what lawyers kind of jokingly call death by 1,000 days.
How about that?
The goal is not necessarily to win, but to for the challengers, win on the merits, but delay so long that the other side gives up and pulls up stakes, goes home, runs out of money, runs out of financing.
Well, we'll be following your analysis on this as the
It's a
weeks or
fascinating.
months
It's a
go on.
fascinating case.
There's another
that's
case.
not over yet.
Another case that you've been commenting on, which is quite fascinating, and it has to do with the rights of Native Hawaiians. And a lot of people don't understand that body of law in and of itself. Maybe you could summarize that before we get into this case that involves a pig hunter.
This is it's what I say, put the pua'a back in ahu pua'a. Because, I'm no expert
gonna get
on
in
the,
trouble for
on
letting
the,
you
on
say
the
that.
Hawaiian language, but ahu pua'as are basic land divisions
Right.
on all the islands.
These
are
districts
the
that
word
run from mountain to
pua'a has its root in a pig. Pua'a.
But before we go on to the specifics, there is this body of law in Hawaii law and with some federal backing that is Native Hawaiian rights.
Yes,
But
and
what is that exactly?
That started, well, it depends who you talk to on this one, but the
That's right.
concrete start of this was in the Constitutional Convention in the 70s. That added
1978.
Yes, that added in provisions that recognized the rights of Native Hawaiians to practice what they call traditional and customary practices. And sort of to compact the story, eventually the question of what are those? Is it the rights that were, or is it the practices of 200 years ago at first contact? Is it at statehood? Where is it? What is it? Those parameters have never been defined, but ultimately the Supreme Court of Hawaii, in a case in the early 1990s, said that what they call the Western concept of exclusivity of someone owning property. So if I own property generally, it's mine, get off,
Right.
I can keep you off of it, isn't universal in Hawaii, because even a private landowner, you got your fence up, you may have to allow in certain circumstances someone who is claiming to a practice, Native Hawaiian practice, traditional and customary Native Hawaiian practices, you have to let them come on your land, and that's not considered either a civil trespass or a crime of trespassing.
Now,
And
this concept that private property is not exclusively owned by the owner of the property is a very profound concept.
it's very
It
profound,
has-
and it's we're very unique in that sense. And although the Supreme Court of the United States was given a chance to look at that decision at the time it was decided, they passed, which to me leaves it still an open question of whether
That's
that's
right.
good or not. But for the time being, that's the lay of the land, so to speak.
Now,
in
I
Hawaii.
recall Prince Kuhio, when he saw the greatness of the United States of America, he established the Hawaiian homelands. And he wanted Hawaiians to be able to have private property ownership. That was the original intention, so that we could be great here in Hawaii like the United States is, based upon this principle called private property. And you know as well as I that that's an international measure economic freedom, the ability to protect private property. So,
Yeah.
so how does this idea that private property is not exclusive affect us ultimately?
Well, it comes up in cases like this because what
Okay.
it was Gay and Robinson, the former plantation land on
Okay,
Kauai.
here we are, the Pua'a case,
private
the pig
property,
case.
and normally that would mean they can either fence it off or whatnot, and
All right.
say you can't come on here. I don't care who you are. You're not with Gay and Robinson, or you're not here with permission.
So they have a deed to this property.
It says fee simple absolute.
They've got a fence around it, perhaps, or something like that. There are
If not a real
boundaries
fence, a legal fence,
and so forth. And basically, they have the strange notion that other people who don't own their property have to stay off.
Right, or at
Okay.
least they get to control the gate as to who can come on and who
Okay,
can come off.
so then take it from there. What happened?
Well, in this case, a person who lived in the Ahupua'a decided to go pig hunting, and he did not, on Gay and Robinson's land, and did not ask Gay and Robinson and did not receive Gay and Robinson's permission, was caught by one of Gay and Robinson's personnel coming off with one or two, pigs on the shoulder that
All
he
right.
had killed with his dogs and his knife, and was ultimately prosecuted by the prosecutor's office on Kauai. So it ends up as a prosecution for trespass. And his defense was that I was not trespassing on their land because I'm a native Hawaiian and I have certain rights to exercise traditional and customary practices. And pig hunting with a pack of dogs and a knife is a traditional and customary native Hawaiian practice.
Well, that's a very interesting
It was a fascinating case.
And what's interesting too is if we were to go back to the time of the chiefs in Hawaii, where the Ahupua'a were administered by the king and the chiefs and so forth, it would be interesting to ask whether you could go on to anybody else's Ahupua'a and have a right to
Right,
pig hunt there.
Generally speaking, and I don't want to speak too broadly about this, but you have to be a tenant or a resident of the Ahupua'a in which you're allegedly trespassing.
Was he claiming that historically?
And he was, and I don't think
his
there was any.
ancestors were?
Yes, and there wasn't
Okay,
any question
so I
in this case that
understand
he actually lived and his
Sure.
he was a descendant of people who had lived in the Ahupua'a.
All right.
And the real question, the real issue in the case was: is pig hunting in this fashion a traditional and customary practice?
Okay, so tell us what the court decided.
Well, ultimately, the court, after a trial, the Intermediate Court of Appeals didn't quite get to the Hawaii Supreme Court on this one, and we're about more than 30 days since the decision, so I think it's not going to get there, and I think rightfully so. The Intermediate Court of Appeals said, in this circumstance, where the hunter brought in folks from the UH academics, PhDs like yourself, came in and testified that yes, this was a traditional and customary practice, and the prosecution did not introduce evidence to say otherwise.
Oh my goodness! So this is another procedural matter
Yes.
here. That
Now,
the
whether they couldn't
prosecutors
find
didn't
anybody
rise
or-
to the challenge.
Or whether, this is a misdemeanor case, and do we want to spend, there's a lot of bad people out there that maybe the prosecutorial dollars of the county of Kauai are better spent chasing the bad guys.
Let me see if I understood what you just said. You basically said, after the plaintiffs made their case, or the defendants, after
Yes.
the defendants...
In this case, it's the defendant's burden. Normally, in a criminal
Right.
case, it's always the prosecution's
So
burden.
his lawyers made their case and brought in their expert speakers to say that this was a traditional Hawaiian rite. The judge said the prosecution didn't rise to the challenge and challenge that, therefore I'm going to have to side with the defendant.
Yes. And the Court of Appeals, when the county or the state appealed that to the Court of Appeals, and the Court of Appeals said that's about right to us, that if you had wanted to prove that it was not a traditional and customary practice among Native Hawaiians in this circumstance,
Fascinating.
you should have proved it.
Before we go to a break, real quickly, what's the ramification of this decision?
Well, I think on this one, there's not going to be much. It's a wait and see. This is a preview of the next case, because on this one, and this is sort of a technical aspect, the Court of Appeals didn't formally publish its opinion. Now, I have a copy of it, which means they published it, but they didn't publish it with
Right.
a capital P, which means it's not precedent for future cases.
Okay.
So they haven't made a ruling as a matter of law across all cases that pig hunting with dogs and knives is a traditional and customary
They were-
Native Hawaiian practice, but what they're giving us is a great preview for the next case when the state actually brings in evidence, maybe, if there is some, to show that it isn't.
They were pragmatically tentative.
There you go.
I'm with
Exactly.
Robert Thomas, learning some fascinating things about the way things really work. We're asking whether the courts are crazy, but it may be not so simple an analysis. We'll be right back after this short message on Think Tech Hawaii's Ehana Kako.
Hi, aloha. My name is Chris Leatham, and I host a show called The Economy and You. The show plays every Wednesday at noon, and on my show, I bring on guests who are interested or working in the technology space. And so I'd like you to come and watch the show and learn with me about all the sort of exciting things that we're doing in Hawaii to build and grow our economy ecosystem. So I'd like to say aloha, and I look forward to seeing you on the show. Thank you.
Hi, I'm Stan, the Energy Man, Stan Osterman, and I'm here to tell you about my show on Friday, every Friday, on my lunch hour, 12 o'clock till 1 o'clock here on Think Tech Hawaii. We talk about everything energy and anything you ever wanted to know about energy. So we're full of energy, and we'll see you here every Friday at noon to 1. Aloha.
Welcome back to our closing segment of Ehana Kako on the Think Tech Hawaii Broadcast Network. If you're wondering what does Ehana Kako mean, we can tell you at the Grassroot Institute there's a venerable old saying here in Hawaii called a pule kako. Everybody knows that here. It means let's pray together. At the Grassroot Institute, we also say Ehana Kako. Let's work together. Think of the terrible alternative if we don't, especially in this small island state. Let's work together whether we're Democrats, Republicans, Green Party, Libertarian, Blue Party, or whatever it may be. Let's build a better economy, government, and society. And I know somebody who's doing that with us is Robert Thomas. Well, this has been fascinating, Robert. And I want to ask you to just touch on very briefly the upcoming environmental court here in the state of Hawaii. What is that?
Well, the legislature last session, or maybe not the last session, but it came into fruition very recently. We're one of two states, two jurisdictions in the entire country that have a specialized court for certain what might be classified as environmental matters.
Now, is that because environmental issues were losing in the state of Hawaii?
No, they were. I mean, apparently you've read Professor Keli'i's study.
Yes.
At the University of Hawaii Law School, who came up with a Supreme Court of Hawaii during about a decade's worth of during the Moon Chief Justiceship, had environmental plaintiffs, if you will, had a stunning success rate.
I think it was above 90%.
Close to it, which
so that puzzles me. It's not as if we were neglecting to consider the needs of the environment.
No, but for the legislature in its infinite wisdom decided that we needed a specialized court to be able to get a cadre of judges trained on these issues. They felt there was some inconsistency, although I have never seen really that kind of inconsistency.
Now, we do know that legislators are elected politically, so that may be a political issue.
This is the result of years of lobbying efforts
There
by environmentalists and others to get this in place. And right now, I think only us in Vermont have these type of court systems.
What do you
in place.
anticipate this means in terms of the conflicts that ensue between environmentalists and developers and others here in the state?
You know, my point was that all of our judges were kind of environmental judges, especially the Hawaii Supreme Court. Environmental battles we have in this state are very highly publicized. Our environmental law is not terribly complex. Like, for instance, California's and federal law can be somewhat complex. Ours is, 5 sections in Chapter 343, and that's it. And there's some case law on that, but there's not a huge body of law out there. It's developing. And so what I think you will see is what I was afraid of was this become a court, as opposed to a court deciding environmental issues, to a court feeling like it had a mission to protect the environment. And that was a little troubling to me when this came up, and I wrote a piece that I posted saying this was a problem in search of a solution.
That would be an example of legislating from the bench, really.
It could be. I mean, that was, I took sort of a wait and see attitude because, and in fact, I think we're about to be deprived of the first case that went to the new environmental court because it was challenged, the cane burning on
That's
Maui was
right.
challenged under environmental laws, and it got assigned to an environmental,
right.
the new environmental court of Maui.
And now there's no
And-
more cane.
And my expectation is that lawsuit will go away. So I think it will, ask me in 10 years, how has the last 10 years been about the environmental court? Has it been?
Okay, it's a date. We'll invite you back then. But
Okay.
before you go now, I know you've been sitting in the Peanuts Gallery for a case called Akina versus the state of Hawaii. I need to disclose to our viewers that I am a plaintiff in that case. And as you know, we have charged that this whole process of the Office of Hawaiian Affairs and the Native Hawaiian Roll Commission to establish an election, to create a body of delegates, to seat them in a constitutional convention, to form a nation, is actually something being done with the sponsorship of the state of Hawaii. They passed a law, Act 195, setting it up. They funded it with millions of dollars. They've administered it by giving out subcontracts to organizations and a bunch of other evidence that we've presented. And you've been sitting in the Peanuts Gallery heckling. What are some of your observations on this?
Well, on this one, I'm watching from sort of an interested distance because I'm not involved in your case. But I find issues like that fascinating because I do election law. And I just happened to be in Washington, D.C. last month for 2 cases that are up before the U.S. Supreme Court on some other issues when your case on your emergency motion came before the Supreme Court. And so I happened to be sitting in a room full of election law lawyers, not from Hawaii. I was the only one there
That's
from there.
interesting perspective.
That sort of set up the horns and the red alert when the Supreme Court decided, rather than throwing you out on your ear, like most of those type of cases end up, actually Justice Kennedy referring it to the entire court, saying that, well, I'm going to put an injunction in place and stop the ballot, if I'm correct, the ballot counting
That's
and then
right.
certification of the
That's
election,
right.
which is an extraordinary step to take as a single justice. And then ultimately, a few days later, I think it was after Thanksgiving, the entire court looked at it and in a 5-4 decision, but without any kind of rationale, agreed and kept the injunction in place preventing Nai Apuni from counting and certifying the ballots.
That's right.
If I remember right.
And what we were waiting to do was appeal to the Ninth Circuit because we lost at the First Circuit here in Hawaii to stop the whole process, waiting for the Ninth Circuit to come. And so we appealed to the U.S. Supreme Court, at least stop the election process until the trial has come. Now, what do you think the action of the Supreme Court to impose an injunction says about their assessment of the merits of our case in the first place? And you're not being paid. You're not involved in this.
No, I'm again just a sort of interested observer on this. I find this stuff fascinating. When I first heard about the process that was in place, I was troubled by it. Court have to be kind of blind not to follow the money, as they say, and figure it out that this is in effect a state-sponsored race-based election or a race-restrictive election.
Sure looks, talks, and acts like one, if I say so myself,
Right.
with the appropriate disclosure.
Not that you have, yes, not that,
but
yes.
Then, as the days went on, interesting things happened. First, the other side decided, well, okay, and I'm paraphrasing. They didn't say this, but they noted that the court had said, don't count the ballots, don't certify the delegates. So they decided first to extend the election because ostensibly the court didn't say you couldn't extend the election for 3 weeks. So they did that. And then in the second week, they called that off and decided at that point that everybody who was running as a delegate can be seated as a candidate. Everyone who was running as a candidate, and at that time is about 200 people, can be seated as delegates in the convention.
I think they went from being candidates to invitees or something like that, right?
And so what are your thoughts about that? Is this, in effect, everybody's a winner?
Well, I've come out and said so. I mean, it's what one very well-known election law professor from the mainland called it's the Oprah theory. Said, you win a car and you win a car, you won the election and you won the election. So instead of having 40 winners, you now had potentially almost 200 winners. So there's nobody who lost. Everybody kind of won. And
now you're aware that we have gone back to the United States Supreme Court and we said, take a look at what they're doing. That doesn't look like they're respecting your original decision for the injunction, and that the court will be hearing that or reviewing that on January the 15th.
January 15th.
What are your thoughts?
Well, that first, when you get Justice Kennedy is pretty much the swing vote on the entire court across a range of issues, not just this.
He's a swinger.
He's a swinger. You convince him, you've gone a long way to convincing the entire court, because on this one there's 9 of them. You don't need to convince all 9, you just need to convince 5 in order to win. Then, following that up, you get 4 other justices who support him a few days later and said, yes, we're going to continue the injunction. There's a majority. It's going to be very hard, I think, and the question now before the court is whether this little move of canceling the election or terminating the election and then inviting everybody was followed both the letter and the spirit of the court's original order saying don't count, don't certify, or was this kind of too cute by half, too clever, nice try, don't. And I'm waiting with bated breath. I can't predict. I do sometimes, but on this one, I really can't predict what the court's going to do. I know what I would do were I a judge or a justice on this one, because they don't like it. In my limited experience, when it looks like people are trying to get around what they told them not to do, and my understanding, or at least the way I looked at it, the court essentially froze things in place to allow the Ninth Circuit to make a decision, and the termination of the election, or the ostensible termination of the election, and calling it off really is going to prevent the Ninth Circuit from looking at it on the merits, which is what I think the purpose of the Supreme Court's injunction was to say, stop, everybody freeze, let the Ninth Circuit make its decision, and we'll see where we go from there. Or as it is now, it sounds like the defendants on this one are going to ask the Ninth Circuit to dismiss it as moot, because hey, there is no election to challenge at this point, right?
A couple of weeks ago, we interviewed Williamson Chang, a professor of law at the Richardson School of Law.
My old mentor, Bill Chang.
He's an old classmate as well, wasn't he?
No, he was a
teacher.
generation in front of me, but he was a teacher at the law school when I was there.
And so forth. And he said he's a delegate as well. He said some profound things in the interview. I think you had a chance to review that.
Oh,
any thoughts you have before we close?
When you get Bill Chang and Mike Lilly to agree about anything, that's a good sign, and I think they both agreed, because
former
I think
Attorney General Mike Lilly, one of the lawyers on our case, was also on the interview.
Right, but as my understanding, and I certainly don't want to paraphrase Professor Chang's views, but my understanding of his views is he believes that the overthrow was illegal, and that Hawaii continues to this day to be a sovereign nation.
Right, that's his personal belief.
That's just not recognized. I would expect that's not exactly a mainstream legal view, but that's his job as a legal scholar to make those points and push it. But when he's saying on this case that the defendants in your case went too far, tried to get around the injunction, well, that's got to count for something. And I think he wrote a piece on that too, about why it was not proper, or why do we need taxpayer money in order for us as Hawaiians, and I'm using that figuratively, us as Hawaiians to meet and figure out what we want to do. And on this one, that would solve the problem, I would think. Not necessarily in your case, but why do we need state money to do this at all? Why can't, the Bishop Estate or one of the well-known beneficiaries of the Keli'i trusts say, you know what, we're going to fund a private meeting, and we're going to have people come, and in that case, a lot of the constitutional challenges would vanish.
Well, in closing, let me let you off the hook in terms of the public relations for our show. We call this, Are the Courts Crazy?
Okay, thank you.
You've got 5 seconds to answer.
No, they're not crazy. They're decidedly not. And I will tape this and give it to the Supreme Court Disciplinary Committee.
As well as the Bar Association.
Exactly. If anyone
Very
challenges otherwise, no.
And I think that as you listen to Robert Thomas, you can recognize there is method to what the courts do, and thankfully so. But at the same time, we live in such a politicized world that rarely is anything completely hermetically sealed and given rationale and law alone to govern. Robert, thank you very much for being with us
Dr.
today.
Kina, Keli'i, thank you very much. Aloha.
And to all of you watching, thank you for watching Ehana Kako every week on the Think Tech Hawaii Broadcast Network. Until next time, Aloha.